is Anurag Singh. Welcome to Pahuja Law Academy. And today we are going to see a recent case, and the name of the case is Navas versus State of Kerala, right? And this case is actually related to the circumstantial evidence, right? Now we have to see what do you mean by circumstantial evidence and what do you mean by direct evidence. There is a distinction between the two. So direct evidence, as you know, this is under section 60 of the Indian Evidence Act, right? And the rule of direct evidence, also known as the rule of best evidence, right? इसमें हम लोगों को देखना होता है कि direct evidence must be of a person, evidence must be of a person who has seen it, ठीक है? Who has seen it or who has heard it or who has felt it, okay? So direct evidence में we have to keep in mind three things, that it must be an evidence of a person who has seen it, who has heard it or who has felt it by any other perception. इसे यहाँ पर लिखा है. So in the section 60 of the Indian Evidence Act, it has been made amply clear that direct evidence is the rule of best evidence, okay? Although there are exceptions to this rule, but we should also keep in mind कि in most cases you will not have direct evidences, and the reason for that is कि most crimes do not happen in the open, they happen behind closed doors, okay? So at that moment you don't have direct evidences, but you will have circumstantial evidences, okay? Circumstantial evidences are very necessary when you do not have direct evidences. अगर direct evidence है तब तो अच्छी बात है, अगर नहीं है then we have to go to circumstantial evidence. And for circumstantial evidence, to establish circumstantial evidence, याद रखना, it's not an easy job. There must be many principles which need to be incorporated in the circumstantial evidence, and the most important one is the chain of circumstantial evidence, okay? So the expression is the chain of circumstantial evidence, okay? This must be complete. The chain of circumstantial evidence must be complete. Now there are many principles governing the chain of circumstantial evidence. For that we have the landmark case law of Sharad, Birdich and Sharda, and this is a case law versus let's not 1984 का case है, this is, ठीक है? Now state of Maharashtra वैसे, but याद रखना कि in this case law there was a principle of Panchsheel, right? Panchsheel, or the 5 golden principles. 5 golden principles of circumstantial evidence, okay? Now we cannot go into the details of all the 5 golden principles because that would take a longer video, okay? But देखो यहाँ पर basically क्या था, सबसे पहला कि the circumstantial evidence of the chain of circumstantial evidence must be complete. It must only be consistent with the guilt of the accused, and all the circumstances must be fully established. It must not conform, मतलब वहाँ पर कोई भी reasonable doubt आपको नहीं छोड़ना है, ठीक है? So all the 5 principles had been incorporated in this case, the Sharad Birdich and Sharda case. This is a very important case and a very landmark one. And before you study section 6 to 55 of the Indian Evidence Act, आपको ये case में जाकर के ये 5 golden principles आपको जरूर पढ़ने चाहिए, ठीक है? And this was exactly what was reiterated in the case of Navas versus State of Kerala. In this case also, there was no direct evidence. So the trial court relied on the chain of circumstantial evidence. And in this case, the court said कि जो reasonable doubt हम लोग करते हैं कि circumstantial chain of evidence के बीच में अगर कोई link missing है, तो वो reasonable doubt का level क्या होना चाहिए? देखो, उसमें reasonable doubt का मतलब minor discrepancies नहीं होता, ठीक है? It means a serious doubt that the accused is not guilty of the offense. It must be of such a level. जैसे कि अगर हम लोग मान लो कि हम लोगों ने circumstantial chain of evidence पूरी complete कर दी, but the accused उसने plea of alibi को prove कर दिया, right? Now the plea of alibi is such a evidence, अगर आपने वो prove कर दिया तो chain of circumstantial evidence पूरी होने के बाद भी the accused will be discharged, he will not be convicted. याद रखना. तो इसी केस में वो बोला गया कि देखो आपको circumstantial evidence of circumstantial chain of evidence की जो completeness होनी चाहिए वो एकदम 100% होनी चाहिए, ठीक है? Although कि 100% is not possible, but still 90 to 95% आपको sure हो जाना चाहिए कि वही होगा. अगर सीरियस डाउट है ओनली देन दे कैन बी रेफर्ड एज टू रीजनेबल डाउट, अदरवाइज माइनर डिस्क्रिपेंसीज जो है दे आर टू बी डिस्कार्डेड एंड द होल पिक्चर शुड बी लुक्ड एट। जो सुप्रीम कोर्ट ने कहा कि एक होलिस्टिक अप्रोच आपको लेना पड़ेगा यहाँ पर इन द केस ऑफ सर्कमस्टेंशियल एविडेंस। ठीक, थैंक यू एवरीवन।